you weren't aware of the fact that the Children's Act is primarily there to describe the rights of our children, our minor children. The Children's Act's departure is from the point of view of what is in the best interest of our children. Good afternoon, my dear friends. I'm Leon Forsman. I'm a mediator and counsellor in private practice here in Johannesburg. In the description below this video, my contact details will be given, as well as email address if you wish to get hold of me after you've seen this video. The Children's Act of 2005, Act 38, as I've already mentioned, its point of departure is the best interest of the child. So whatever the parent decides for their children, it needs to be in the best interest of the child itself. Both parents have equal rights. Let me say this right in the beginning of our discussion this afternoon. Both parents have equal rights. Unless a court has impaired some of the rights of one or both of the parents, both parents have equal rights. And when a divorce takes place and a parenting plan is negotiated and put into place, that document works from the point of view, once again, of what is in the best interest of the children. It has very little to do with the rights of the mother and the father in the first place. It's a practical plan that is put on the table so that all the needs and wants of a child can be described and taken care of, so as to help parents act in the best interest of their children. Each parent, now having two households, need to assign to each other certain responsibilities so that whatever is in the interest of the child is served to the best of their abilities. Let me stress this. In the first place, the Children's Act is not about the parents' rights. I've said it, but I'm saying it again. For instance, a dad stops paying his maintenance as required by divorce decree. He may think in the process, because his ex got remarried or whatever the facts may be, think, well, he's getting back at her. And therefore he's infringing on her rights. But the sad part of it is that it's not her rights that is being infringed upon. It's the child's right to proper care which is in peril. The moment the dad or the mom stops paying maintenance. And that can lead to the child's physical, emotional, and psychological damage because he or she was not taken care of in a proper manner. What about the following? I hear this quite often. Mom stops to to send the children to their dad for the weekend. She's the primary residence of the child. And for the majority of the time during a week, the children live with mom. Dad, in accordance to the parenting plan, has certain times and days he has contact with the children. And now mom goes and she stops sending the children to dad. Every time he wants to come and pick them up, she has a new excuse of why the children cannot go to them, to their dad. In this instance, the mom is violating the rights of the children once again, as was the dad when he stopped payment of the maintenance. Because the Children Act states very clearly that the children have a right to meaningful contact on a regular basis with both their parents. Both examples, dear friends, are commonplace in today's society. But may I stress that both of them, although it does not look like it on the surface, are both criminal acts according to our law. I've heard of dads that got fined and got a jail sentence of up to 5 years for not paying maintenance. I've also heard and experienced a mom that got sanctioned by a court because she did not adhere to the contact with the father and the children. According to the Children's Act, the rights of the child is paramount, and there are 4 rights described within the Act that are of more importance than all the other, and in a certain sense encapsulates all the rights of a child. The first right that it describes is that a child has a right to be taken care of, not only physically with food and housing, but also emotionally and psychologically. A child, the Act sets out a child needs to be taken care of. The second thing that the right that the Act makes provision for is the one of contact. And here again, it has to do with meaningful and regular contact between the the parent and the children, both parents. Therefore, it's usually advisable that the parents stay after the divorce in the same vicinity so that both can be involved in their children's lives. When either of the party wants to move away, it would infringe on the rights of the child to have meaningful contact with the parent moving away. Then that has to be discussed, and a new parenting plan has to be put on the table, which makes which helps us to address that situation. The third right a child has is the right to education, to proper education. And fourthly, he has a right to his religion and whatever he chooses to be his or her religion. And may I say this as well. These 4 issues, or these 4 rights, are usually the big issues when a couple gets divorced, especially if there was especially if the divorce is highly contested, everything becomes a problem. The Act makes it compulsory to have a parenting plan in place. A parenting plan is a plan that describes how the rights of the children is going to be dealt with by both parents. In that sense, parents get certain rights and have certain obligations towards the children as well. So the first thing when parents get divorced is get a parenting plan in place that describes how, when, where, and under what circumstances the children will see both parents have meaningful contact with both parents, are taken care of in a meaningful way, and so forth. When people get divorced, there are usually two courts involved in the whole process of divorce where children are involved in. The one is the divorce court, which helps to settle the divorce, to make sure that everything is taken care of in an amicable way, and that the property and everything that was accrued during the marriage is settled in a equal fashion, so that both parents feel they have what they need. Secondly, there is the maintenance court, which then deals with how to take care of the children. And then thirdly, the family advocate, and in some cases the family courts are involved and deals then with the parenting plan and everything that is part of that plan. And as you have heard, much of what is in the maintenance plan also has to be described in the parenting plan. And no divorce will be granted without a parenting plan. And no parenting plan will be made an order of court without maintenance being provided for the children. However, the Act makes it compulsory also that mediation be part of the process, especially where children are involved. So any divorce or separation where children are involved and a parenting plan needs to be put on the table, mediation is advised. It has all to do, once again, with the children and their best interests. And a parenting plan takes care of that. But it needs to be negotiated between the parents and not between lawyers. And therefore, a mediator is best suited to help couples reach an agreement in terms of a parenting plan. The Children's Act also makes provision that the child's voice is heard. And it has to be stated in the documentation that the child's voice was heard and taken into consideration when the finer details of the parenting plan was negotiated. I would urge, if a couple decides to separate or get divorced, and there are children involved, please go and see a mediator before knocking on a lawyer's door. The mediation brings the tempers and the temperature between the parties down and helps the couple focus on the needs and the wants, the best interests of the children first and foremost. There, in a nutshell, I've discussed the Children's Act and how it works and what is important and what you need to know if you are contemplating getting divorced. Thank you very much for listening to me this afternoon, and may you be blessed, and may all the disputes and conflicts in your life be resolved amicably. Thank you.